And specific page at page 17. Hardly, Lordship. Next page, Lordship, may kindly see. Bas.
No, the problem is that if you were not warranted in the case, if you were not required for any purpose, then why should we grant you release?
Show Lordship, why? Next page, Lordship, hardly.
Hmm.
Hardly, the filing of a first information report is not a condition precedent
Hmm.
to exercise of the power under section 438. The imminence of a likely arrest founded on a reasonable belief can be shown to exist, even if an
That's
FIR
all right. We have considered that aspect. We have granted you relief on yesterday.
Yes, Lordship. That may be continued, Lordship. Till filing of the FIR. In the next page, it is there till filing of the FIR, it can be done. Till registration of the FIR, it can be done, Lordship.
No, but we do not know whether any case will be registered against you or not.
Yes, but there is,
Hmm?
we have been again called to visit a police station on the day after tomorrow. Again,
What is this, madam? Why he has been called?
no. I need to show whether I have a reasonable apprehension there. And it is,
In the report, Lordship, it is also to be mentioned that on 18/4/2024, one complainant, namely Sandeep Kumar Mehta, so and so, lodged a written complaint against the person, namely Mr. Parveen Kothari and Pankaj Kumar Kothari regarding a business-related issue. The complaint has been entered in Nunmati PS, GD number so and so, and inquiry interested on SI Abdul Momin. The inquiry officer informed the same to the complainant named person to know the actual fact. This.
what preliminary inquiry accused does not require, discreetly it can be done. That is what Lolita Kumari also says, Lordship. Again, constitutional bench decision.
Hmm.
And
So, one FIR has been filed. Madam, as per report.
Complaint on 18/4/24.
Hmm. Okay, madam, you produce the report, we'll see
Yes, Lord.
after some time.
Lord.
Next item.
For admission, item 2. Item 2 for admission.
After some time.
Item 4, bail hearing.
May I please, Your Lordship? 439 application, Your Lordship, in connection with Lordship case number 104/24 under section 120B, 420 and 511. Lordship,
CD received, Mr.
CD not
Soma?
received, my lord. CD not received.
So, is there any material against him?
Lordship, may I please submit it? Lordship, the allegation against me is that
Where is the FIR?
FIR page 15, Lordship.
Page 15.
Fake gold was found from my possession.
Pardon?
A metal suspected to be fake gold was found from my possession.
Hmm.
I am 25 days behind the bar.
20?
25 days.
Well, short date may be given, my lord. I will produce the case there. Short date may be given, my lord. I will produce the case there.
You are?
Short date, my lord.
Why?
I prefer short date, my lord. To produce the case there, my lord.
No, you have not received the case.
Today not received, my lord. Today not received.
Lordship, as per the FIR, Lordship, there is no victim whom I attempt to cheat it, or
Hmm.
the section what imposed in this case, Lordship, it is not applicable.
Hmm.
The mere possession of fake, Your Lordship, was found from my possession.
Heard, Mr.
Ke Thakur, my lord.
Learned counsel for the accused and also heard Mr. B. Sharma, learned additional PC for the state response. This application under section 439 service is prepared by accused Zakir Hussain, who has been languishing in jail since 5/4/2024 in connection with Gorsuk PS case number 104 of 2024 under section 120B 420 511 IPC for grant of bail. It's to be noted here that above noted case has been registered on the basis of one FIR lodged by one Mujibul Islam, SIO Police, Gorsuk PS on 5/4/2024. The essence of allegation made in the FIR dated so and so is that on 5/4/2024, in connection with one GD entry number 62. Now, in connection with STFPS GD entry number 62 dated 4/4/2024, a search was conducted and a person namely Mohammad Zakir Hussain Ali was apprehended with suspected fake gold in both shaped, wrapped with pink colored cloths having on a weighing 1.84 grams. The learned counsel for the accused submits that the accused was arrested on 5/4/2024 and for last 25 days he has been languishing in jail Azut. Further, learned counsel for the accused submits that what is your submission?
Lordship, there is no victim whom I tried to cheat, Your Honor, as per as the LS section is 42511, Lordship.
That no ingredients of the offense under section 120B 420 511 IPC, though the case has been registered under the said section of law and there is no victim whom the present accused attempted to cheat, and that he is ready to cooperate with the investigating agency and therefore it is contented to allow the petition. On the other hand, Mr. B. Sharma, learned additional PP submits that though he was directed to produce the case before this court, yet he has not received the same and prayed for granting him some more time. However, considering the submission of learned advocates of both sides and also considering the facts and circumstances on the record, this court is inclined to dispose of this petition without perusing the case theory. Full stop. It appears that the accused was arrested on 5/4/2024 and he is behind the bar for last 25 days. Further, it appears that suspected to be fake gold weighing 1.84 grams was seized from the possession of the present accused, but there is no allegation that he had tried to cheat any person. by selling the aforesaid white gold. Having considered above and also considering the nature and gravity of the offense, as well as the punishment prescribed for the same, and further considering the period of detention, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one surety of like to the satisfaction of the learned Chief Judicial Magistrate Kamrup M, the accused being Larjan Bay. All call করে দিন।
Item 5,
15.
May it please your lordship.
Yes.
My lord, 439 application, my lord, and petitioner before lordship is in custody for last 41 days, my lord, and he is a delivery boy. His duty is to take the, my lord, the ordered item from the godown, my lord, and deliver to the customer. That's his duty. And here a strange allegation has been made, my lord, that the FIR, my lord, will find at page 8, my lord. That my only duty is, my lord, the manager is there, manager has given the order item to me, and my duty is to take the item and deliver it to the customer. That's the only duty. If something has been interchanged in between, my lord, for that, my lord, someone who is working the inside of the godown may be responsible, my lord. That's number one. Secondly, my lord, he was taken police custody, and he was of further custody was given. He was thoroughly grieved. And now 41 days, my lord. So further custody may not be required, my lord. And the statutory period is 60 days, my lord.
What is this, Mr. Sharma?
My lord, CD received, my lord.
This switch
lord.
the item inside the bag, inside
lord,
the
here-
package.
Here from the statement, it reveals that, my lord, sticker, my lord. Sticker was changed, my lord. From one to the another, my lord, and they have sent one delivery, my lord, that is 8,000 or something, my lord, and others, they have, my lord, misapproved from the statement, my lord, clear, my lord.
My lord will see, kindly see. My lord, a godown is there, my lord. Their managerial persons are there, and I am not allowed to enter into their godown. I am entitled to go to their gate. And on the gate, my lord, the item has been given to me, and my only duty is to deliver it to the customers. And here, my lord, they have brought some allegations that a costly item has been given some packet, and it was given to somebody else. That is how that can be, my lord. It was a packed item, and whatever packed item is given, I was supposed to give to the customer, and I have given. I have given the customer, and if any delivery items is not, my lord, the customers are not willing to take and take it yet, I get it back and deposit to the, my lord, go down. My only duty is from the gate to the customers. And if anything has been changed in the, within the, my lord, the package item, packed item, that is done within the, but the, go down. I don't know, my lord. There may be some exchange in between. Otherwise, my lord, whenever I will bring back a consignment, my lord, that is the pack, seal.
No, what offense is made out?
My lord.
Hmm?
Well, from the statement, it reveals that, my lord, he has
And articles, my lord, no description, nothing of the sort, in how many times, what is the idea? And normally, my lord, if the value is high, normally it has been prepaid. Payment has been done to the company, and thereafter they have take the item and then give it to the delivery person. And today is, my lord, 41 days, my lord, 41 days,
40?
41 days, my lord. And stated period is 60 days, my lord.
So, Mr. Somo, what remains to be investigated here?
My lord,
Hmm? Heard Mr. M.S. Chaudhary, learned senior counsel, assisted by
T. Chakraborty.
learned counsel for the accused, and also heard Mr. B. Sharma, learned additional PP for the state respondent. This application under section 439 CRPC is prepared by accused Krishna Sharma, who has been languishing in jail Azut in connection with Jalukbari PS case number 147 of 2024 under section 120B 406 420 IPC for grant of bail. It is to be noted here that above noted case has been registered on the basis of one FIR lost by one. Dhanajit Kalita
Honjit,
of
Honjit,
Dhanjit
Yes.
my lord.
Dhanjit Kalita of Itas Delivery Technology Private Limited, Azara. On 28/3/2024, the sense of allegation made in the FIR dated so and so is that one Krishna Sharma, along with one customer, namely, no, on 19th March 2024, one delivery associate, namely Krishna Sharma, along with a customer, namely Jaswant Singh and Dhanesh Singh, are found to be involved in fraudulent activity wherein the customer and the associate has switched the item inside a package which amount to rupees INR 20 lakhs 9,770, and the package was then brought back to the delivery center by the associate, stating that the customer denied to provide OTP. And further, the parcel was rejected by the customer, Jaswant Singh, within bracket, Jaswant Singh and Dinesh Singh, whom he assumed to be the same person. And he has a reason to believe that the delivery associate Krishna Sharma is involved in the fraudulent activity and acting in and indulge in impersonation. The learned counsel for the accused submits that the accused was arrested on 28/3/2024, and since then he has been languishing in jail Azut for last 44 days.
41 days.
41 days. 41 days. Further, it is submitted that the case has been registered under section 120B 406 407 420 IPC, and the period of punishment, maximum period of punishment prescribed is 7 years.
Right.
And as such, the mandatory period of detention is 60 days, and that the accused is innocent and nowhere involved with the offense alleged, and that he is ready to cooperate with the investigating agency, and therefore it is contented to allow the petition. On the other hand, Mr. B. Sharma, learned additional PP, has produced the case before this court and submits that the IO has collected sufficient incriminating materials against the present accused, and therefore Mr. Sharma contended that the bail petition may be dismissed. Having heard the submission of learned advocates on both sides, I have gone through the petition and the documents placed on record, and also perused the case with the assistance of Mr. Sharma, learned additional PP. It is not in dispute that the accused was arrested on 28/3/2024, and since then he is languishing in jail for last 41 days. Further, it appears from the case that the IO has collected some materials in support of the allegation made in the FIR, but it also appears that the material part of the investigation is almost over, and in the interest of investigation, further custodial detention of the accused seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the learned CJM Kamrup M, the accused be enlarged on bail. Case there will be returned.
Highly oppressed.
I'm sorry, my lordship. I'm also praying for listing my lordship.
When?
Next week, my lordship.
Okay, take
On
a date
sixth
from him.
Of last
Sixth on sixth.
6th.
May I please, Your Lordship, I victim is item number 15, Lordship.
1-5,
1-5, Lordship.
yes.
For adjournment for the day, Lordship.
Why?
A Khonigur is out of business.
Mr. What is your name?
RL Sutia also.
Mr. R.L. Sutia, learned counsel appearing on behalf of Mr. A. Khonikor, learned counsel for the appellant, press for listing the matter on when?
Any date, any next,
On 28th May.
Lordship.
28 May, as the conducting counsel, Mr. A. Khonikor is out of station. There is a lot. Recessal list the matter on 28th.
Timing item number 18, promotion.
Please, Lord.
Pardon?
Instruction, Lordship.
Ah,
Case is registered, Lordship.
case is registered.
Lordship.
What is the number?
Hailakandi PS case number 113/24, Lordship.
113 of 2024.
Under section 420 and 506 of IPC.
So produce the case, Aiden.
Lordship.
Ms. Endos learned additional PP obtaining necessary instruction. Submits that in connection with that submits that a case being Hailakandi PS case number 113 of 2024 under section 420/506 IPC has been registered against the present applicant. In view of above, it is provided that Ms. Das shall produce the case before this court on
13th of May, Lordship. 13th of May.
no sorted
Then Lordship, 9th of May, Lordship.
9th of May.
Lordship.
9th of May.
May I pray for interim, my lord?
Let the city come.
Fine. I live.
Item number 19, pending matter.
So where is the provision for preliminary inquiry before registration of the FIR? Hmm? Okay, person to order dated 29/4/2024, Ms. Endas learned additional PP has produced a written report from the officer in charge Nunnmati Police Station. Dated 30/4/2024. Perusal of the report reveals that one FIR has been received from one Sandeep Kumar Nahata on 18/4/2024 against Mr. Praveen Kothari and Mr. Pankaj Kumar Kothari regarding a business-related issue, and upon the said FIR 1 GD entry being Nunnmati PS GD entry number 27 dated 18/4/2024 has been recorded, and preliminary an inquiry is entrusted to SI Abdul Momin. In view of above, it is provided that Ms. Das learned additional PP shall produce the said GD entry along with the complaint. Along with the written complaint lodged by Praveen lodged by
Sandeep Kumar.
Sandeep Kumar Nahata along with the inquiry report on when after election. Till then, interim order dated 29 4/2024 shall continue.
17 May,
Short date
13 May.
13 May.
Much obliged.
Timing item 2 for admission.
This is my lord, criminal petition under section 482. Kindly see the FIR, my lord, which we are praying for quashing, page 13. The relevant page is page 15, my lord. With due respect and honor, the undersigned begs to inform you that a few months ago, it has come to the knowledge of the undersigned that one Minu Subba has obtained a birth
So
certificate.
whether notice was served upon the respondent.
My lord, they are appearing.
Acha. Then whether case diary is it solicited case or
No, my lord. The investigation,
investigation is going on?
Charge sheet, my instruction is charge sheet has been prepared and filed.
Search sheet has been prepared and filed. When? No, whether case diary was called for here.
the investigation was stayed, how can there be charge sheet? Are you talking about the same FIR?
Yes, by order dated 7/9/2023 investigation state.
Lordship. Okay, FIR 207, no? 207.
207. And why investigation was stayed, my lord? The allegation is that when I was only 6 months of age, I manipulated and got a birth certificate in my favor when I was 6 months of age. That is the basic allegation. If your lordship look into the FIR, and the allegation has been
That's all
brought
right,
by-
but without perusing the case diary, would it be proper to hear the matter?
So, my lord, that is why the investigation was stayed. Prima facie, the FIR itself is having no material, my lord. Kindly have a look at the FIR, my lord.
Hmm.
Page 15, my lord.
No, when the FIR was lodged.
It was lodged on 23rd of February. And the birth certificate
No,
was issued,
then till 7/9/2023, they might have examined some witnesses
my lord,
till 7/9/2023 on which the investigation is stayed.
my lord.
Till then, they might have examined some witnesses.
Might be, my lord, if that your lord.
So is it not necessary to go into the case diary?
Lordship, that will be proper, Lordship.
Let the learned
Scan copy
additional
they
PP
can
to
bring-
produce the case diary. We will
Scan
hear
copy,
you.
they can bring this one, scan copy, Lordship.
No, since the investigation
lordship
is stayed,
only-
you produce the original case diary. Heard Mr. S.K. Singh, learned senior counsel assisted by Mr. Learned counsel for the petitioner and Mr. Chakraborty, learned
For respondent number 2.
counsel for the respondent number 2 and Ms. N. Das, learned additional PP for the state respondent number 1. It appears that by order dated 7/9/2023 investigation of the case has been stayed by this court. But it appears that the FIR was registered on, what is the date of result?
23rd of February, my lord.
23rd of February 2023. 23 or 22?
23, my lord.
23. And in the meantime, the IO might have examined some witnesses and therefore perusal of the case diary is found to be necessary. And accordingly, it is provided that Ms. N. Das, learned additional PP shall produce the case diary before this court on suggested date
13th of May, Lordship.
13th of May,
My lord, can it be fixed in the month of June, my lord?
June. Okay, no problem.
Or either on
Suggested date then.
10th June, my lord.
10 June. Okay.
Highly obliged.
Bail hearing item 6.
Please, Your Lordship. Lordship, the petitioner was sworn arrested in this instant case, Lordship, on 5/4/2024. Earlier, he was arrested in connection with Atasil Ambari PS case,
When he was soon arrested here.
5/4/24.
Yes.
The allegation is lordship under section 420, 468, and 471 lordship regarding forging, regarding use of forging a EWS certificate lordship.
Hmm.
The FIR is on page 14 lordship.
Whenever you receive the case,
My lord, I have received the case
Oh,
there, my
Sharma.
lord. My lord. I have received the case there, my lord. He is the person who issued the, my lord, fake EW certificate, my lord. Thereafter, it was verified to the circle officer, my lord, office of the circle office, my lord,
Hmm.
and it was said that it was not issued from the circle office, my lord. And from the statement of the other witness also stated, my lord, it was co-accused, my lord.
And what is the
Lordship, my name is Pinit Gordon, Lordship. Lordship, in the FIR, it is specifically mentioned that the certificate is given by some Vivek Mondal, Lordship, who is co-accused of the case, Lordship.
no? What is this annexer 1, page number 9,
Annexure 1, Lordship, the
forwarding report?
forwarding report in connection with another case, Lordship.
Another case.
Lordship.
Where is the forwarding report of the present case?
Present case, Lordship, prayer for sworn arrest is on page 16, Lordship.
Page?
Page 16 and page 17 is the order for sworn arrest, Lordship.
And page 14 is the FIR.
Lordship.
Yes, Mr. Sharma, what is the stage of
My lord,
investigation?
investigation is going on, my lord. Some of the accused persons are yet to be arrested, my lord. Some other people, other persons are also involved in this case, my lord. And they have issued several, my lord, such type of certificate, my lord. Here's the informant is the, my lord, brilliant, my lord. He has resigned from SBI clerical job thereafter get job in the postal department. But due to the fake certificate issued by the present petitioner, my lord, his service was terminated, my lord.
In the FIR, Lordship, it is written that I have just confirmed the
He is the also habitual
Complainant.
offender, my lord. He is another cases, he was already arrested, my lord, from the fake currency note, my lord.
And that's all right, but whether further detention is required here?
My lord, material is sufficient, my lord.
Materials are
Sufficient-
there, no doubt.
My lord, sufficient material and
Hmm.
custody is
He
also
is
required.
already behind the bar for 25
My lord.
days.
Custody is also required for by the
I have
arrest other persons also, my lord.
Lordship,
Hmm.
I have already taken to.
He has said
police
that
custody.
some Raju is involved, my lord, but not mentioned the name and address also there, my lord. And report also, circle office report reveals that, my lord, and not such type of, my lord, certificate issued from the office, my lord.
In the FIR, it is written that Lordship, I have not issued that, that
No, no, all are involved, all are involved.
FIR authentically.
FIR, that is different, after investigation found his involvement.
I am permanent resident of Guwahati, Lordship, Lal Ganesh. I'll appear
Not at
before
this
the
stage, my lord.
Heard Mr. Solimson, learned counsel for the accused, and also heard Mr. B. Sharma, learned additional PP for the state respondent. This petition under section 439 services preferred by accused Binit Bardhan, who has been languishing in jail since 5/4/2024 in connection with Bosista PS case number 205 of 2024 under section 420, 468, 471 IPC for grant of rape. Is to be noted here that among the case has been registered on the basis of one FIR lost by one B2 Poddar on 29th March 2024. The essence of allegation made in the FIR dated so and so is that one Vivek Mandal has issued one fake EWS certificate to him and thereby cheated him. The learned counsel for the accused submits that the accused was shown arrested here in this case on 5/4 on 5/4/2024. 5/4/2024, and since then he is languishing in jail for last 25 days. And he was also arrested in connection with, what is the case number?
Patasi Lambari PS case number, Lordship.
In case of Patasi Lambari PS case number
104 of 24.
104 of 2024
Under section 489B, 489C of IPC.
under section 489
B and C. Page 2.
489B and 489C IPC. And that he is no way involved with the offense alleged in the present FIR and is also ready to cooperate with the investigating agency, and therefore it is contented to allow the petition. Whereas Mr. B. Sharma, learned additional PP, has produced the case series before this court and submits that the IO has collected sufficient incriminating materials against the accused, and some of the co-accused are yet to be arrested, and therefore Mr. Sharma has opposed the petition. Having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record, and also perused the case diary with the assistance of Mr. Sharma, learned additional PP. It appears that the accused was arrested on 5/4/2024, and since then he has been languishing in jail as for last 25 days. The accused was soon arrested. He was already arrested in connection with Patasi Lambari PS case number
104.
no. Earlier case was a Bosisto PS case.
Earlier case was Patasi Lambari.
Patasi Lambari, present is
Patasi.
Bokis.
What was the number case was case number
104 of 24.
104 of 2024? And in that case, he was arrested on
20 March. Lordship.
21,
20 March. Lordship, 20 March.
20
24.
March
24.
2024. 2024. The case diary indicates that the IO has collected some materials in support of the allegation made in the FIR. But it also appears that the IO have achieved substantial progress in the investigation of this case. And in view of his detention for a period of 25 days in Jailazut, his further custodial detention in the interest of investigation seems to be not warranted here in this case, and therefore this court is inclined to allow this petition it is provided that on furnishing a bond of rupees 50,000 or once a return like amount with the satisfaction of the Lord at CJ and Kamrofen, the accused be enlarged and by case there will be returned.
Item number
I have
9,
next. Well, in item number 9, we have not received case diary, my lord. Here an interim.
Mr. B. Sharma, Lord at additional PP submits that he has not received the case ID. Accordingly, it is provided that Mr. Sharma shall produce the case ID before this court on
on 22nd May.
till then interim order dated 4/4/2024 shall continue.
Item numbers 11 and 12.
May it please the lordship, my lord, I am for 12, my lord. Regular bail, my lord. My lord, the petitioner arrested on 10/4, my lord. FIR is page number 14, my lord. 1/4, under section 407. 406, page number 1/4, my lord. Petitioner is my lord Salman Hussain Mazumdar, and the FIR is lodged against my lord Shubham Das, the driver of the vehicle, page number 14, 1/4, my lord. Subject mentioned, my lord. Shubham Dev is the driver, and owner is the Rafiqul Islam, my lord, of the vehicle. My lord, lodged by the transporter, my lord, Om Prakash Chubey. He entrusted the goods, my lord, to the driver of the vehicle, my lord. On 2024, my lord, and on the same day, my lord, he knew that the driver, my lord, is switched off while proceeding to Silchar and Juai. But surprisingly, FIR is lost after 4 days, my lord, without any, my lord, explanation, my lord. Now, my lord, the petitioner is arrested, my lord, by calling him from his workplace. He was a security guard in the Paslam paper mill, my lord. I have annexed his identity card, my lord. On the suspicion that, my lord,
Where is the forwarding report?
my lord, page number 18, my lord. 1/8, my lord.
Page number 18 is
Sorry,
the
20,
Caesar list.
my lord, 20, my lord. Caesar is, my lord, the personal mobile phone of the petitioner, and 20, my lord, ground of arrest, my lord. That one of the mobile number is that, my lord, from where it is mentioned that, my lord, the communication was made.
So there is a allegation of impersonation.
My lord.
Yes, my lord.
Mhm.
And two, my
So
lord,
impersonation is what is section 419?
407, my lord, is the entrustment, my lord.
419 is available perhaps.
419.
Yes, bailable offense 419. Mr. Sharma,
lord.
what are the materials against him?
My lord, here we have received the case, my lord. Here, he has given one phone number, my lord.
Hmm.
That is last is 168, my lord.
Hmm.
And on the basis of the investigation, my lord, it is found that, my lord, he himself, although he has introduced himself as the Rafiqul Islam, my lord, but the owner of the SIM phone number is Mr. my lord, the present petitioner, my lord, arrested accused person, my lord. And after investigation, it is found that, my lord, there is a contract between the accused person and the informant, my lord. It was CDR, from CDR, it reveals that, my lord, উক্ত মোবাইল নম্বৰৰ পৰা গুচৰীয়াৰ লগত যোগাযোগ কৰাৰ লগতে নিৰুদ্দেশ হোৱা গাড়ীখনৰ চালকজনৰ লগত যোগাযোগ হোৱা বুলি প্ৰমাণ পোৱা যায় on the IO note, my lord. It reveals, my lord.
Hmm. But how do you link this missing of articles of worth 40 lakhs
My lord.
with the present accused?
No, my lord, it is from the phone number, my lord. When it was booked, my lord,
Hmm.
it was given in the phone number was, it was called from the that number, my lord. And introduced himself as the owner of the vehicle, my lord.
Impersonation
Oh, my lord.
419
Owner of the
available,
vehicle,
available.
my lord. Then thereafter it is found that, my lord, that he is not the present person, my lord.
Hmm.
And there is a, from the IO note, my lord, it reveals that there is a, my lord, contract to the informant.
IO note will not do. Mr. Sharma, is there any witnesses who have implicated him with the missing of this article of worth 40 lakhs?
That is
No material.
statement, my lord, complaint, my lord.
No, whether any materials have been recovered? Yeah,
not
no.
recovered. Vehicle also not recovered. And the investigation is also very initial stage, my lord.
Hmm? Initial stage, that's all right, but unless some materials are there, he's behind the bar for last
20 days.
how many days? 20 days.
20 days.
20 days.
What material is also not mentioned, my lord, in the FIR. What articles he, my lord, booked, it is also, my lord, not mentioned, my lord.
Hmm. Heard Mr. M.J. Kadir, learned counsel for the accused, and also heard Mr. B. Sharma, learned additional PP for the state respondent. This application under section 439 services prepared by accused Salman Hussain Majumdar, who has been languishing in jail as in connection with Basista PS case number 231 of 2024 under section 407 IPC for grant of bail. It's to be noted here that above noted case has been registered on the basis of one FIR lost by one Abu Bakr, no, lost by one. What is the FIR?
Om Prakash, my lord, page number 14, my lord, 14.
On the
Om
basis
Prakash.
of one FIR lost by one Om Prakash Sobe on 3/4/2024. The essence of allegation made in the FIR dated so and so is that he is the proprietor of a transport company in the name and style Om Roadways at Nalapara Kalimandir Road, and on 30/3/2024 he had loaded a 12-wheeler truck bearing registration number AA01 LC 7377 with various items of worth rupees 40 lakhs and sent the same to the consignee of Silsor, but after reaching Zoai of Meghalaya, the truck has gone to be untraced. And the mobile number of the driver is found to be switched off. Mr. Kadir, learned counsel for the accused, submits that the accused was arrested on 10/4/2024, and since then he is languishing in Zelazur. Mr. Kadir further submits that the accused is an employee of Pascam Paper Mill. And to substantiate the same, he has enclosed the identity card of the accused at page number
24, my lord. 24, my lord, not paper mill, but he is a employee of the security company, my lord.
Pacha.
Security company, Dolphin
He
Security
is
and
an
Advising.
employee of security.
Dolphin Security and Advising Agency, my lord. Under this, he is acting of the Pasgram Paper Mill as security, my lord. Page number 24, my lord.
He is an employee of
Of my lord, Dolphin Security Advertising.
Dolphin Security and Advertising,
And employed at Pasgram Paper
which
Mill.
is being engaged in the security of Pasgram Paper Mill. Pasgram Paper Mill, and that he is no way involved with the offense alleged in the FIR. And nothing has been recovered from his possession, and therefore Mr. Kadir contended to allow the petition. Whereas Mr. Sharma, learned additional PP, has produced the case diary before this court and submits that the IO has collected some material in support of the allegation made in the FIR, and he has impersonated himself as the owner of the truck bearing registration number AS01 LC 7377 by using his mobile number 8453882168. And that investigation is in nascent stage, and therefore Mr. Sharma has opposed the petition. Further, having heard the submission of learned advocates of both sides, I have carefully gone through the petition and the documents placed on record, and also perused the case diary with the assistance of Mr. Sharma, learned additional PP. It appears that the accused is languishing in Zelazur since 10/4/2024. And further, it appears from the case diary that the materials collected so far are quite inadequate to show the complicity of the present applicant with the offense alleged in the FIR. And in that view of the matter, his further custodial detention seems to be not warranted here in this case, and accordingly, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one surety of like amount of the satisfaction of the learned chief judicial magistrate Hailakandi, the accused be enlarged on bail. Case there will be returned.
Sorry, my lord, it is CGM Kamruk. He is in Guwahati jail. CGM Kamruk.
The case has been, oh, yes, yes.
CGM
CGM Kamru.
highly offensive.
Yes, in respect of AB number 1055.
Item number 11, my lord. Dear my lord, resident of Bodorpur, my lord, under Koringal district, my lord. Suddenly, my lord, they have received, my lord, brother and sister, two petitioners. Page 14, my lord, and page 16, they have received two notice to appear before the IO. They are, my lord, totally, my lord, ignorant about the incident, my lord. Even this arrested person also, I act, they don't know about him also.
Yes, Mr. Sharma, anything
My lord,
against the present applicant?
my lord, regarding the present application, only 41 notices there, my lord. And
Nothing.
my lord,
Why 41 notice was issued?
no, 41 notices already given to them, my lord, but they have not.
No,
applied,
why? Is there any material in the case diary to
Not,
show their involvement?
not present,
No,
my lord. I
no.
am seeing only that is initial stage, my lord. And CD also not up to date till today, my lord. Whatever found, that is, my lord, up to 14, only to the forwarding date, my lord. Last entry, my lord.
Okay, heard, Mr.
AM Borbin.
Learned counsel for the applicant, and also heard Mr. B. Sharma, learned additional PP for the state respondent. Apprehending arrest in connection with Bosisto PS case number 231 of 2024 under section 407 IPC. This application under section 430 each service is preferred by two applicants, namely Salimuddin Barbuya and Nurjahan Begum. Barbuya alias Nurjahan Begum for grant of PSP. Director is paragraph number 3. Yes, what is your submission,
My
Barbuya?
my submission is that, my lord, their brother and sister, my lord, innocent resident of, my lord, Bodorpur, my lord, town, my lord.
Why you are apprehending arrest?
They are, my lord, recently they have received two notice, my lord, petition of 1 and 2, my lord, to appear under 141, my lord, 41. A, my
A,
lord, of- yes,
41.
my lord, CRPC, my lord. Therefore, they are apprehending that, my lord, they may be
Why,
arrested.
why the 41 notice was issued to you?
My lord, they are totally, my lord, ignorant about the incident. I asked them, my lord, even they, my lord, they are not aware. And my lord, personally they do not know the arrested person, my lord, who preferred, my lord, bail application before your lordship, my lord. Totally, my lord, they are
Mr.
ignorant.
Barbuya, learned counsel for the applicant submits that the applicants are innocent and no way involved with the offense alleged in the FIR. And they are also not acquainted with the person who was already arrested here in this case. And they have received notice under section 41A CRPC from the IU concerned. And that they are ready to cooperate with the investigating agency, and therefore Mr. Barbuya contended to allow the petition. Whereas Mr. B. Sharma, learned additional PP, has produced the case there before this court and submits that as the investigation is in nascent stage, there is no incriminating materials against the present applicant except issuance of 41A notice to the applicants. At this time. After this having heard. But in view of the materials collected so far in the case area, as well as the submission of the learned advocates about the parties, custodial interrogation of the applicants seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that in the event of arrest of the applicants in connection with Bosisto PS case number so under section so they shall be released on periodic bail under executing a bond of rupees 50,000 each with one surety of like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following 3 conditions. Last condition, they shall not leave the jurisdiction of CJM Kamrup M without prior permission.
Item number 20,
They will appear within 15 days, my lord. Keep local.
City not received, lordship.
And thus learned additional PP submits that she has not received the case in. And press for granting her some more time. Here is allowed. Press is at least the matter on when?
on 24th May.
24th. Sort that.
Interim is not there.
15th, Lord.
Sort that.
On 8 of May, lordship.
8th of May, okay.
All right. Item number 13, part matter for those.
Lordship, my lord, we are for bail well. And so far the merit of the case is concerned, lordship may kindly say, let me discuss the criminal appeal, my lord. They are
No, on the other day, perhaps we have asked you that we can finally hear and dispose of both the matter.
Yes. And lordship had advised the senior counsel to go through the Gurmeet Singh judgment. Yes, I have brought today the Gurmeet Singh judgment. That is nothing is new there. That is still only the statement of the victim is enough, provided the same is free from any doubt. That is the crux of the case. But here is, my lord, so many differences are there. Here it is not in such a place that incident happens that there was no way. From, my lord, this Manikpur to Tezpur, and in another witness said he was taken to Bilasibara. So many persons, he was 3 days in, a person was in that house, there are so many persons. So the Gurmeet Singh's case is, I think, not applicable in this case. Over and above, my lord.
No,
my lord,
in
only-
Gurmeet Singh case, Supreme Court has laid guidelines as to how the evidence of victim of sexual assault has to be appreciated. The facts may not be similar with the present case.
Yes.
The why the bail should not be cancelled, my lord. My reply is my argument on one matter, my lord. And I was in behind the bus for many a days, 82 days, my lord. There
Oh,
are
how many days?
82 days, my lord. I was behind the bus. And accordingly, thereafter, the bail was granted, my lord. So his basic ground of filing I could get, my lord, that it's a desperate character. At page 8, my bail cancellation petition, my lord, ground number 4, is the accuser of desperate character taken law into their hands to get rid of the deceased, and threat perception amongst the family members of the deceased is apparently describable, and considering the nature and gravity of offense, the impugn order dated demand granting bail is bad in law and set aside. So, my lord, till now, my lord, not a single adverse remark has been brought into the record by any means, neither in the trial court or neither before this honorable court also, my lord, that I have any way misused the liberty granted or I have threatened anybody, my lord. So that is the basic consideration which will also come up for your lordship kind consideration, my lord. Post release on bail, what was my role, my lord? I have never interfered with the administration of justice, my lord. Neither I have tried to induce or influence any of the witnesses. And in this case, my lord, will kindly note, my lord, there are 28 probably charge sheeted witnesses, if I'm not wrong, can you see it? 26 witnesses, my lord, and 4 official witnesses, IOs, my lord. Total 32, no? So out of that, 15 or 17 witnesses already examined and as on date, my lord. I cannot be sure of the figure, my lord, but last
All total 30 numbers of witnesses.
32,
32.
of which 26 are non-official witnesses. 6 are official witnesses like IO, FSL. Yeah, bro, eight. FSL 27. 27. Take up a side. My instruction, as I could gather, my lord, some 15 to 17 witnesses has already been examined, my lord, and they have come and freely examined before the court. They have not said anything as such. And so far, this. One point which I'd also like to just throw light before entering into the legal aspect, my lord. My lord, this client was never named in the FIR, my lord. But that doesn't absolve me from the case. I have been brought in under the circumstance evidence, but not a single circumstance has been spelled out in the charge sheet, my lord, as to what are the circumstances appearing against me. Just submitting on the merit, my lord, because Dr. Mogdum and 2 others were charge sheeted in the case. Oh, sorry, were named in the FIR. Out of that, the 2 other accused named in the FIR were not charge sheeted. Eyewitness accounts FIR, my lord. If your lordship will kindly look into the FIR, my lord.
No, should we enter into the merit of the case?
Yes, ma'am.
At this
No,
stage?
the one aspect. Now, your lordship, apart from the other consideration, that is also one consideration which the Supreme Court are categorically stating. So what was the post conduct even after release me on the bail, my lord?
No, that is you have already submitted.
Yes, yes, that is all, my lord.
Mm.
I am just pointing it out, my lord. That I was not actually named in the FIR in this case, unlike his client, Dr. Mogdum, my lord. He was named in the FIR. 2 person, another was also named in the FIR. But when charge sheet was submitted, those 2 FIR name was also missing, my lord, in the charge sheet, my lord. Subsequently, they were brought in on the petition of 319, my lord. So that is the merit, my lord. But so far I am concerned, I am no way mentioned in the FIR, my lord. I have only brought in by way of circumstance evidence into the case, my lord. So that is the merit, my lord, I'm submitting. And whether I have disturbed the proceeding or I have interfered in the dispensation of criminal justice system, which is totally missing, is not available in my case. Now, my lord, the legal aspect which I'd like to point out, my lord, your lordship has already gone, and certain things which I'd like to point out. Wait, that one is a good one. Joypura judgment का था। कोई लगी तो। Got it, man. Got it, man. So the judgment which he is relying, my lord, conversing Mina's case, my lord, the main, your lordship will go through everything, my lord, but he has read para 10, which is the relevant, my lord. So here, my lord, the Honorable Supreme Court says that while cancelling the bail, my lord, will kindly take page 186.
Para number?
My lord, page is 186 in the right hand.
Yes, para number?
Para 10, my lord.
Mm.
Para 10, next page, your lordship, at small b, my lord. Your lordship got it on the right hand side, B, my lord.
Yes, yes.
While cancelling the bail under section 439(2) of the code, the primary consideration which weigh with the court are whether the accused is likely to tamper with the evidence, which I have not done, or interfere or attempt to interfere with due course of justice, I have not done, or evade the due course of justice, I have not done, I am participating in the trial. But that is not all. Yes, my lord. Let's pause for a moment. The High Court or the Session Court can cancel the bail even in case where the order granting bail suffers from serious infirmities resulting in miscarriage of justice. So if we peruse the order, there is no serious infirmities in granting the bail order, my lord. He has considered everything, my lord, and thereafter he has granted the bail. When there was no miscarriage of justice, my lord, that infirmity, my lord, has not caused any miscarriage of justice. If the court granting bail ignores the relevant material, he has taken the relevant materials into consideration, my lord, indicating prima facie involvement of the accused or takes into account irrelevant materials. So here no irrelevant material was taken, which has no relevance to the question of grant of bail to the accused. The High Court or the Session Court would be justified in cancelling the bail. Such order are against the well-recognized principle underlying the power to grant bail. So now if your lordship will pause for a moment and see what are the infirmities, if any, has been committed by the trial court while granting the bail, my lord. Your lordship has already read it, but still, just to harpen my point, my lord, we like to take your lordship to the bail order, which starts at page 38, my lord. Oh, no, page 40, my lord. In the middle, in the well, so just to pinpoint, my lord, time is short. Probably your lordship will be rising also now. I'll finish it, man. In the FIR, shall I read that?
Take minute.
Page 40. Page 40, man. No, 40,
Yes.
Well, I think our paging is 40, my lord. In the middle, my lord. The lordship got it. In the FIR, the informant was stated that on 21/3/22 at around 7:30 p.m. at Bitari Chowk, while the accused, Rimima Begum was coming out from the house of Binoy Doctor with her elder sister coming in a motorcycle. Accused number 1, Mogdom Ali, that is his client, my lord, grabbed Rima Begum by her neck, and accused number 2, Jumma Abdul Rahman, stepped on her stomach and killed her. Thereafter, accused number 1 and 2 fled away in the motorcycle driven by the accused number 3, Chintu. But surprisingly, the police did not charge sheet the FIR named accused Jumma, Abdur Rahman and Chintu and charge sheeted the accused Mogdam Ali, Mohibul, that is me, Maila Mohibul, Robiul Ali, Mustafa Ali, Rokibul Islam, Rafiqul Islam and Abbas Ali instead. The allegation leveled against the charge sheeted accused Mogdam and Mohibul is that they have hired the other charge sheeted accused person to commit the murder of Renima Begum and the other charge sheeted accused person committed the murder of Renima Begum as aforesaid. But the investigation officer could not apprehend the charge sheeted accused Rafiqul Islam and has shown him as an absconder. Further, the charge sheet, the investigating officer stated that he could not collect the examination report of the exhibit sent to the FSL Khanapara Guwahati and has stated that during trial, he will try to submit the examination report of the FSL in the court. This does not make any sense. It seems to deprive the accused person from getting statutory bail under 167(2) of the CRPC. The investigating officer has submitted the charge sheet within the statutory period. So, one hand, we have shown it, my lord, it was filed on the 91 days. Mr. Talukdar has shown it yesterday, and your lordship wanted to know about a judgment passed by a coordinated bench. My lord, I have got it, my lord. That is in 2025, 5 SCC, my lord, page 47.
2020?
My lord, I'm giving, my lord. Wait a minute. 2020, my lord, I don't know. 2022, I mean, 22. 2022, volume 5, my lord. I'll give it, my lord. I have jotted it down, my lord. GLT को कुछ बोल. It's 2022 5 GLT 4 page 405, my lord.
Yes. Any other point?
Oh, yes, my lord. My lord, other point is that, my lord, that the trial is proceeding at his own pace, my lord. No interference from the accused side, my lord. No trade perception is there. And for that, I'll just read one full judgment, which is always relied upon, my lord, while taking the bail consideration, considering the bail rejection petitions, my lord. Bail cancellation petition, that is AR 1984, Supreme Court 372.
AR 19,
1984 SC,
page number?
page 372, my lord.
Yes.
Yes, my lord. This is Bhagirath Judeja versus State of Gujarat, my lord. The relevant para is 5 and 6, my lord. Very cogent and overwhelming circumstances are necessary for an order seeking cancellation of bail. It is now well settled by catenary of decision of the Supreme Court that the power to grant bail is not to be exercised as if the punishment before the trial is being imposed. The only material consideration in such a situation are whether the accused would be readily available for his trial and whether he is likely to abuse the discretion granted in his favor by tampering with evidence. If there is no prima facie case, there is no question of considering other circumstances. But even where a prima facie case is established, the approach of the court in the matter of bail is not the accused should be detained by way of punishment, but whether the presence of the accused would be readily available for trial or that he is likely to abuse the discretion granted in his favor by tampering with the evidence. So in my case, my lord, all these circumstances which has been narrated by the Honorable Supreme Court is totally missing, my lord. And the second judgment, my lord, is 2019 Criminal Law Journal 3780. Kali,
State versus Shakul Hamid.
yes, my lord. State versus Shakul Hamid, my lord. Page is 3780. My lord, in that case, my lord, I am relying on para 15 and 16, my lord, from the Honorable Supreme Court. If I go directly, my lord, it will be para 18, my lord. In this case also, my lord, Nia case, my lord, the PP filed a extension petition. The backdrop is that, my lord, for granting of extending the period of time, my lord, as your lordship is aware, my lord. the PP has to file a petition, my lord, for extension of time. That was rejected by the Supreme Court. So the near being agreed by the High Court order came up for revision under that provision, my lord. That the High Court order was wrong, my lord. So coming to para 18, my lord. Can I take your lordship to para 18, my lord?
Yes.
We cannot be obvious of the changed circumstance which have been brought to our notice regarding the present FIR dated 26 January 2017. Charge sheet has been filed against all the 4 accused persons, that is A1 to 4, including the accused respondent number A3 on 13 March 2018 and the accused number 2 and accused number 4 are on bail from 23rd January and 19 November 2018, and the matter is pending for framing of charge, and it is not the case of the appellant that the present accused respondent, after being enlarged on bail in compliance of the impugned judgment dated demand
That's
has
all right, but there is no contention on
Yes,
the
ma'am.
part of the petitioner
there has
that
been
you have
any breach
violated
or
the
a
bail
violation
condition.
of the bail condition. So here also there is the change circumstance that the bail was granted to them and they have appeared. Then one more large judgment, my lord.
Not necessarily.
Just
my
one
lord.
more one. Guri Bhai. So these are the judgments, my lord, which I am relying, wherein it has been taken care of it, my lord, that even if bail is granted and there is change circumstances, even then bail should not ordinarily be cancelled, my lord. With this, my lord, I leave your lordship. Thank you. Consideration, my lord.
Yes, Totoki, any reply?
Ma'am, in this case also, I am relying on the judgment, earlier we can place with your lordship. I'm not saying paragraph 10, my lord. Because the consideration, my lord, for grant of bail was not
Oh,
irrelevant.
the other day you have pointed it out.
Yes, that I'm
Okay.
reiterating the same.
Heard Mr. Kotoki, learned counsel for the petitioner, and Mr. Jet Kamar, learned senior counsel, assisted by Mr. So-and-so. Learned counsel for the respondent number 3, and Mr. D. Talukdar. Learned counsel for the respondent number 2.
I am
And
three, my
Mr.
lord. State of Assam is respondent 1.
Mr. Sharma, learned additional PP for the state respondent number 1. Argument concluded, order reserved.
Much.
Item 14,
Much
for hearing.
May I please, your lordship? We are engaged counsel in this case. We
Who
are
is
not-
engaged counsel?
Pardon, your lordship.
Who is engaged counsel?
We are-
Acha.
We are not in contact with, we are not in contact with the petitioner, and brief is not with us. Kindly allow us some time, your lordship.
Time
Yes,
on the appeal being made by Miss
P. Roy,
P. Roy, learned counsel for the appellant.
Jet Alam,
Pardon?
Jet Alam.
On behalf of the
Learned counsel appearing on behalf of Mr. Zaid Alam, learned counsel for the appellant, raises and list the matter on when?
On 30 May, 30,
Is it up?
30 May.
Obliged, your lordship.
हाँ, जिंदाबाद
नहीं आया फाइल ड्यूटी का इस बार।
उनका फिक्सेशन वाले
मोरी बिजन तो लो इश्यू लगे हां